The following podcast is taken from a live broadcast on Inspire FM.
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to the Ask Your Lawyer show at Inspire FM. My name is Mujeeb Rehman, solicitor.com solicitors, and for the time being I'll be your host and your presenter as the guest of the show. Mr. Qazi is running slightly delayed, he's stuck on his train, so we do apologize in advance. However, we'll proceed with the show and the contents of what we were going to talk about today. Those of you who are frequent listeners are probably aware that me and Mr. Qazi have been on the show on many occasions, and we mostly talk, whenever we've been here, we've always spoke about housing laws and issues pertaining to housing laws. Now, we briefly touched upon possessions and evictions beforehand. However, we didn't really go into much detail, and we didn't cover it quite substantially. So today, the topic is possession and evictions. Now, when it comes to possession and evictions, there's certain things and certain criteria that needs to be met. So, we've covered tenancy agreements before here as well, just briefly to touch upon it. So we've spoken about short hold, assured, fixed, and various kind of tenancy agreements, leasehold agreements as well we've covered. So those of you that want to know a bit more, I'm sure the podcasts are available on the Inspire FM website or the Facebook page. You can listen into them through there as well. Just to recap it, it's too much of a vast topic just for me to start talking about it again when the topic of the show is something else. Now, generally speaking, assured tenancy agreements are short-hold tenancy agreements are mostly used in private rented sectors. So most of the listeners, I take it, I could be wrong, are probably private rented tenants or landlords who are privately renting their accommodations. And assured tenancy agreements are mostly used by the councils, housing associations, trusts, and other organisations such as the Women Refuge Development and Centre. They'll mostly issue the women that seek refuge from them an assured tenancy agreement. So, as mentioned before, today we are going to focus on eviction and possession and the laws pertaining to eviction and possession. Landlords cannot just evict the tenants out of the property just as and when they please. Now, landlords have to follow strict legal procedures and certain regulations in order to evict their tenants or to leave their properties. The exact procedure, however, depends on the tenancy agreement itself, and depends what type of tenant you are. We've covered it in the previous show before, where we explained what a tenant is, what a lodger is, how long a lodger needs, how long a tenant needs. So basically, just a brief difference is a tenancy agreement. Generally speaking, your rent is either periodical or monthly, on a monthly basis. However, if you're a lodger, it's just an agreement by way of mouth. You're lodging in somebody's house, and it's a weekly payment that you're paying. So it's a bit different. So for now, I'm just going to focus on tenants of a property. The most common eviction notices that are served are, obviously, we have the Section 8 notice, and we also have what we call a Section 21 notice. And these are covered by the Section 8 notice is obviously covered by the Section 8 of the Housing Act 1988, and Section 21 notices are covered by Section 21 of the Housing Act 1985. However, the most common out of the two at this precise moment, from what I've seen through my experience as well, and just commonly what's mostly used, is Section 21 notices, whereby a landlord will issue a tenant with a Section 21 notice in order to evict them. And they're generally granted on a short hold tenancy agreements. However, I'm going to touch upon a bit of the law, explain it as well. So, the Section 21 of the Housing Act, the landlord does not need to give any reasons for possession of their property. They don't need to list out reasons. They don't need to justify and... let me rephrase that. They don't need to give an explanation, a detailed explanation as to why they want to evict the property. However, there are legal requirements before a landlord can serve a Section 21 notice. And under Section 21 of the Housing Act, in a Section 21 notice, in order to evict your tenant, you either do this after the fixed tenancy agreement ends, if there was a written contract in place, and obviously the contract will have the date of commandment and the date it expires or finishes. So upon that, you could serve a Section 21 notice. And during a tenancy agreement with no fixed end date, known as a periodic tenancy. Again, like I've mentioned before, we have spoken about periodic tenancy agreements. And just visit the show. I'm sure it's going to be on the Inspire FM webpage. The podcasts, I'm sure you'll be able to flick through them. I believe it was sometime in January this year or February this year, I believe. We did cover tenancy agreements and tenants and what type of tenancy agreements there are. What's a periodic tenancy? What's a fixed tenancy agreement? What's a short? What's a short hold? What's a short hold, etc. Now, for a landlord to give a tenant a Section 21 notice, a landlord has to give them a Section 21 notice by filing in a form called a Form 6A. If the tenancy commenced or was renewed after the 30th of September in 2015. However, if the tenancy agreement came into force or came into play before the 30th of September 2015, a landlord can just write a Section 21 notice by himself. Mostly, I'm talking from my short experience of working as a solicitor. Most landlords do not write Section 21 notices themselves. They either go to professionals, lawyers, it could be letting agents, or the agents that they've put in place to manage their property. They get them to write the Section 21 notice to serve them. Again, that's only if the tenancy agreement commenced before the 30th of September 2015. However, after the 30th of September, they have to fill in a form called a Form 6A and file it. However, again, with Section 21 notices, if it's a periodic tenancy, the landlord has to give an explanation as to why they're giving a notice under the Section 21 notice. So again, I know I'm talking about tenancies and different type of tenancies and where the Section 21 applies and how. Yet again, I do apologize for those that do not understand the certain differences between tenancy agreements. It would be my pleasure to go through everything, but yet again, as I've explained before, please visit the Inspire FM website, our webpage, and I'm sure you'll see the podcast of when we talked about the tenancies and different types of tenancy agreements. I'm sure it's up there. It was probably sometime in February, January, February, beginning of the year, we did cover all this. So again, if you're getting confused regarding this, please visit that podcast, take a listen, and there's various other podcasts within the webpage which you could also go through. I mean, there's podcasts on immigration, crime. So the Ask Your Lawyer show will give you a wide range of information on certain legal aspects. Now, everybody thinks, or is probably thinking right now, how much notice must you need to give in order to serve a Section 21 notice? And the answer to that question is that a landlord, when he serves a Section 21 notice, he must give his tenants, the landlord must give the tenants at least 2 months' notice to leave the property. They cannot just serve you with a notice and say, you know what, goodbye, I don't want to see you again. Legally, they have to give you a 2 months' notice under the Section 21 notice in order for you to vacate the property. However, if it's a periodic tenancy, you must also let your tenants stay for any additional time. So a landlord must allow his tenants to stay for any additional time covered by the final rent payment. So with the periodic tenancy, there's a certain period that you pay upfront rent for. So it could be 3 months rent upfront, 4 months rent upfront. So every 4 months, once that rent's gone, you'll put down another 4 months rent. So just to give you a synopsis, person A is a landlord, person B is a tenant, person B goes to person A and says, look, enters into a periodic tenancy. And monthly rent is £250. But he pays £1,000 every 4 months. And now if the landlord wants to evict this particular tenant, what the landlord must do is obviously serve the Section 21 notice, but the landlord also has to bear in mind that he's paid rent. So imagine he's paid £1,000 2 months later, or a month later, sorry, I beg your pardon. A month later, the landlord decides to serve him with a Section 21 notice, which is valid. The tenant... the landlord must allow the tenant any additional time that's covered by his rent. So instead of leaving on the 3rd month, the landlord must allow him to live there for the 4th month that is covered by his rent also. Now, this particular information that we're going to go through now is mostly to do with landlords. So what must the landlord do after he gives a notice? Now, a landlord must have proof to say that he served his tenants with a notice. It can't just be, yeah, I've served you with a notice, it's done. No, you must have a proof, either by filing in a certificate of service, which is a form N215, or right served by the landlord's name on the date on the notice. And sometimes for precautionary reasons, the landlord do take a picture, or they will send it via recorded delivery, so they've got proof of receipt from the tenant. And there's various other ways. I mean, it's just common sense, really. It's nothing that requires any legal knowledge. Again, if the tenants do not leave by the specified date, the landlord can make a possession order, can make a claim for a possession order. So he puts forth a claim for possession on his property. Now what that means is the form is actually called a claim form for possession. So you either fill it in and file it into your local county court, or you go to a solicitor who does housing law, and he fills it in, takes your instructions, fills it in and files it on your behalf. But there are certain rules that landlords have to bear in mind in order to make the Section 21 notice to be effective. And there are some documents which the landlord must have and must obtain before serving with the Section 21 notice. And these notices, these documents and these rules and regulations are covered by the Deregulation Act 2015. And obviously the Deregulation Act is it's not an old act, it's a fairly recent act. And it came into force as more and more people are now, with the market prices of properties so high, moving into rented accommodation as to buying their own properties. And the government have thought that they need to put a law to protect these masses that are moving to rented accommodation. So the law also provides a kind of regulation for landlords to have greater clarification on their responsibilities and protection of the tenant's deposit. A Section 21 notice, however, cannot be given if, as a landlord, you breach any of these regulations which relate to the conditions of the property, i.e. the health and safety and the occupiers, and the energy performance compliance certificate. Also, we're living in a day and age where everything that we have, our phones, our electrical, we use computers, everything that we have is mostly run on electricity. All our appliances, aren't they? So, in accordance with the Deregulation Acts, and for your Section 21 notice to be effective as a landlord, you must have in place a gas safety certificate, which the gas safety man will come check if all the pipelines are secure, etc., and there's no leakage, etc. An energy performance certificate, just to know the electricity is fine, it's running well, the appliance, just to do the regulatory checks. And again, you'll need an electrician for that. And a how to rent book. It's a booklet produced by the government that gives a checklist of renting in England and Wales. And obviously make sure the tenant's deposit is in a protection scheme. A Section 21 notice, however, must be on a Form 6A if your tenancy started or was renewed after the 30th of September 2015. But if it's prior to this date, that need not apply. You need to give the tenant at least minimum 2 months notice. And if they pay rent quarterly or every 6 months, they're entitled to a notice of equal period, as I've explained before when I was talking about a periodic tenancy. Now, when a tenant is given a Section 21 notice, you as a landlord have to start court action within 6 months, because the notice will become invalid if you start the possession after that. So within 6 months of serving the notice, so imagine you serve the notice in today, 2 months later the tenant's still in the property. After them 2 months, you have 2 to 4. From the second month, you have up to the 6th month in order to start your proceedings for the claim for possession. It does result in a hearing, and you'll be represented by a solicitor or yourself in a county court, and the tenant will do the same, and then the judge will make an order as to what should happen and how should happen. You cannot serve a Section 21 notice, or you cannot use a Section 21 notice. Rather, let me rephrase that. You cannot use a Section 21 notice if what I'm going to say now applies. If it's less than 6 months that the tenancy has started, you cannot use a Section 21 notice. If the fixed term has not ended, unless there's a clause in the contract which allows you to serve a Section 21 notice. You can't serve a notice if the fixed term date has not ended and there's no clause. You're not allowed to serve the tenant with a Section 21 notice. However, if the fixed term hasn't ended but there's a clause within your term of tenancy, terms and conditions of tenancy, that the landlord, you as the landlord, have the right to serve the 21 notice, then you can. But if you don't, then unfortunately you can't. You can't serve a Section 21 notice if the property is a HMO, which is a house which is in multiple occupation, which means, for example, it's common in Luton anyway. I'm sure most of our listeners are from Luton, where there's a house and there's plenty of people living in that house renting one room, you can't serve them people with a Section 21 notice. Or if the council have served an improvement notice in the last 6 months on the property, your Section 21 notice is effective. So if, for example, the council's been around because the tenants complained or something, and they've visited your property and done a few checks, and then served you with the improvement notice saying this is not livable conditions, you need to do this, you need to get certain works done in your property, then you can't serve a Section 21 notice if the tenancy started after April 2007 and you have not put the tenant's deposit in a deposit protection scheme. If the deposit is not in the deposit protection scheme and the tenancy started after April 2007, unfortunately you can't serve a Section 21 notice either. And of course, this goes without saying, if you don't have a landlord's license, you shouldn't even have tenants, so therefore unfortunately your Section 21 notice will again be invalid or ineffective. Now, we're touching up to break soon for the ads. So just to give you a slight run through, we've just gone through Section 21 notices, and I have said a few points here. We've spoke briefly about the procedures. What does the landlord need, or how should you give a tenant a Section 21 notice? And we spoke about the few things. We spoke about a few points. If the tenancy started after was renewed after the 30th of September 2015, then you must file a set form 6A. However, if it started before that, you can serve a Section 21 notice as long as it's got your name and the date within the notice, on the notice, then it's a valid notice, obviously. We spoke about the duration of time you must give your tenant upon serving the Section 21 notice. The duration of time you should allow your tenant in the property is 2 months, obviously, unless it's a periodic tenancy, in which I explained if you're holding the money, you must allow them to stay for that periodic term. We spoke about what happens after you give the notice. We touched upon the Deregulation Act and the documentation of justification that the landlord, as what a landlord should hold or have possession of in order for the Section 21 notice to be effective. We spoke about the gas safety certificate. We said the landlord must have a gas safety certificate, an energy performance certificate, a deposit protection scheme, and a how to rent booklet. And we also said the things that must be within, or the things a landlord should do in order for the Section 21 notice to be effective. We said be on a Form 6A. If the tenancy agreement was after the 30th of September 2015, give 2 months notice. Again, with the periodic tenancy, it depends on the amount of rent or the that you have left behind or that you've taken, and you extend it to that period, the end period. And again, we spoke about if the tenant doesn't leave, you must start your proceedings for possession within 6 months of the date that you serve the Section 21 notice upon the tenant. And we also spoke about, when the Section 21 notice does not apply. And we spoke about if the tenancy agreement started within 6 months of the tenancy agreement. If it's less than 6 months, there's no Section 21 notice. If the fixed term's not ended unless you have a clause within the tenancy terms, to state that you're allowed, you as the landlord are allowed to issue a Section 21 notice, or if the property is a house in multiple occupation, or if you've received an improvement certificate from the council, or if the tenancy started after April 2007 and there's no deposit protection scheme. And if you don't have the landlord's license, if you don't hold the landlord's license, therefore you can't issue a Section 21 notice. Now, before we go on break, just to let you know, after break we will be talking about Section 8 notices, which are covered by the Housing Act to 1988, and we'll go through Section 8 notices and what's the procedure on the relevant documents that a landlord must hold and what type of grounds they are in order to serve. So I'll see you after the break, inshallah. Assalamu alaikum.
You're listening to an Inspire FM podcast, making available our popular programs from our daily broadcast on Inspire FM.
Assalamu alaikum wa rahmatullahi wa barakatuh, everyone. Welcome back to Ask Your Lawyer show. My name is Mujeeb Rehman. I'm your host today, and unfortunately it looks like I'm your guest as well, due to a train delay and train signals. So Mr. Amr Qazi does apologise. He's still not turned up, and I've just spoken to him and he's saying he's still stuck at Wheat Hampstead on the train. So before the break, I introduced obviously the topic of discussion today, which was possession and evictions in regards to housing laws. However, we did cover Section 21. So those of you just tuning in, there's a lot of information given out. So please look through the podcasts again. And I did mention before the break that we are going to talk about Section 8 notices. Now, Section 8 notices are again covered by Section 8 of the Housing Act 1988. A tenant may receive a Section 8 notice at any time during the life of the tenancy. Unlike the Section 21 notice, it's slightly different, because with the Section 21 notice, the tenant cannot be served a Section 21 notice within 6 months of the tenancy. However, with the Section 8 notice, it's at any time during the term of the tenancy. However, there is, with Section 21 notices, we did mention again that there's no need for any reason for the landlord does not need to give an explanation or reasoning as to why he's serving the tenant with the notice. However, with the Section 8 notice, you do need to have grounds to serve that notice. You do need to have reasons. You do need to give an explanation and explain as to why. And I was just about to slip it out of my tongue, but we'll go through it as we proceed. I'll talk to you about how many grounds they are and what they are. A Section 8 notice is only valid if there's an assured tenancy agreement or an assured short-hold tenancy agreement between the landlord and the tenant. And there are a lot of grounds in which a landlord can rely on in order to use a Section 8 notice. But there are some that you'll never come across, in terms of, you do come across, but they're very rare. And the most common, however, are rent arrears. You get them all the time. Landlord has served the tenant a Section 8 notice due to rent arrears. Damage done to the property by the tenants, causing nuisance to neighbours. However, a landlord must specify which ground or grounds they choose to rely on of the section in the Section 8 notice when they are citing their reasons for eviction. So in the Section 8, you need to give reasoning as to why you're proceeding with the eviction. Now, the grounds for eviction for a Section 8 notice can be found in Schedule 2 of the Housing Act 1988. However, the grounds fall into two main categories. So this is how I break it up in order for me to understand it better. They're the mandatory grounds, which are from 1 to 8, and then there's discretionary grounds, which are 9 to 17. So when it comes to the mandatory grounds, if the landlord can establish grounds 1 to 8, the possession order will be granted as their mandatory grounds. Because they're mandatory grounds, it'll get granted. However, when it comes to discretionary grounds, the court has the decision. The decision of the possession lies within the court, so by the judge. So if the judge decides and believes and feels it's reasonable to grant the possession order, they will do so. If the judge feels that it's unreasonable, they won't. Now, again, the landlord is required to give from 2 weeks to 2 months. So the landlord has 2 weeks to 2 months in order to grant. The landlord must give 2 weeks to 2 months notice when he serves the Section 8 notice. It can't just be a 2-day notice, or it can't be a 24-hour notice. There's no such notice in accordance with Section 8. The notice also must state clearly and why the landlord wishes to seek possession. It must be stated clearly, and you can't just say tenant is in rent arrears. I know that's clear, but you have to be you have to specify how much in rent arrears. So it must state, i.e., the tenant is in rent arrears of £3,500. His monthly rent is in the sum of £1,500. However, the tenant chooses to pay £1,000, so is short by £500 on a monthly basis. Just to explain it better. And obviously, upon the serving of the Section 8 notice, the tenant must pay the remedy or the breach to the landlord. And if the landlord makes a application for possession, then the tenant again is liable for the court costs, the landlord's solicitor's fees, etc. So, just to give you a brief understanding of how Section 8 works. However, when it expires, the landlord can make a possession for the can make an application for the possession of the property, and the type of possession order can vary. It totally depends on which grounds of the section of Section 8 that has been established. The landlord can decide to make an outright possession order. You could be granted with a suspended or a postponed possession order. If the tenant walks into a courtroom and says to the judge, look, I was having shortfall in my housing benefit, the backdating my payments, I'm receiving in 2 weeks, I'll be up to date with the landlord by this date, then it'll be suspended. The judge might say, okay, I'll suspend it for 6 weeks. I'll issue a suspended possession order, suspended for 6 weeks. However, if the rent isn't cleared in 6 weeks, it'll be granted. And it could also be a money judgment against you. So the county court might just put a money judgment on you. Now, I think there was a brother that was calling in. I don't know if he's going live. But again, with outright possessions, outright possession means that the tenant has to leave the property on the day stated. So on the date stated, which is usually 14 days after the court makes the order. So if the order was to be granted today, it'll be the 13th of August. So by the 13th of August, the tenant must have left. However, there are exceptional circumstances where they will extend it to 6 weeks, i.e. if the tenant has young children who are babies and they've got nowhere to go, if they're ill, terminally ill or disabled, these kind of illnesses. Or you can ask the court just to delay it by 6 weeks. But you again need a reasonable excuse for them to do so. They won't just do it because you're saying to do it and you think you won't find a property in 6 weeks. That's not a reasonable excuse. A reasonable excuse would be, I've got a young kid, my child is not well, etc, etc. Now again, I mentioned suspended or postponed possession, and I did explain briefly. But a suspended or postponed possession order means that you can stay in your home as long as you keep to the conditions, as I gave an example before. And these conditions are always going to be explained explicitly on the court order. For example, the example I gave earlier, you may be ordered to pay off your rent. You may say, that, the judge may order that, okay, you're in arrears of £500, but your housing benefits started again, so your housing benefits paying, and you say, I could afford £50 on a weekly basis to clear off my rent arrears. The judge might say, okay, so you've got 10 weeks now, so every week on top of your rent, every month on top of your rent, I want you to pay your landlord £200. And I think I've got a caller by the name of Aftab. So, Assalamu alaikum Aftab.
Wa alaikum salam. Vakil sahab, theek ho?
जी ठीक ठाक ठीक हो तुसी
जी अल्लाह पाक का शुक्र है
जी क्या सवाल था आपका
जी सवाल पहली तो गल है सवाल से पहले मैं ये यहाँ के तुसा जो शो कर रहे हो पे बहुत चंगा है क्योंकि काफी मालूमात होनी है
जी
बट मिगी थोड़ी जी प्रॉब्लम है तब इंशाल्लाह अगर तुसा कोई मिगी ओ गोरे आने वाले राइट डायरेक्शन इस में करी छुड़े आता है अल्लाह सां भला करसी इंशाल्लाह
क्वेश्चन पूछो
गल ये है कि असां ने घरै विच तकरीबन 5 साल होने से पे बंदे उथे रहने पे
ओके
पर ओ ये है कि जन निकलने ना नहीं किन्ने पे हुन असां आए हैं कि जन असां आपो उथे रहने चाहने हैं
जी
पर वो बाहर नहीं निकलने पे समझ को नहीं इसनी हूं क्या किया जाए तुम्हें पता नहीं सेक्शन 21 तो पता नहीं और सेक्शन 8 तो सेक्शन 10 तो पता नहीं और केड़े तो दसे ना बट समझ को नहीं इसनी क्या किया जाए
जी आफ्ताब साहब ये जरा सवाल तुसां पूछा बहुत अच्छा सवाल है बट इसने मैं तुसें ब्रीफली बना ए टेनेंसी एग्रीमेंट जड़ी है एक्सपायर्ड हो गई है
पता नहीं उसले अब्बे होना जानना की घरै विच बाड़िया सी ते हुन क्योंकि आपको समझ को नहीं इसने के काफी परेशानी हुई है निकलने नहीं पे
अच्छा
तुसा इस कोई टेनेंसी एग्रीमेंट पता नहीं हुई है कि कोनी हुई कोई पता नहीं हाले सही नहीं
तुसा
वो आने पे असां ते मतलब पहले पैसे दिते सन डिपॉजिट भी दिता सी ते पता नहीं और क्या पर 5 साल पुरानी गल है
अच्छा ते वालिद साहब को ना पूछी सकदे
वालिद साहब और वो तो मुश्किल है उन्हें को पूछना
ओ क्यों
ओ फिर बंदा जिला अल्लाह ने वाला हो जाए फिर उसने को किसा बंदा पूछी सकदा
सॉरी बेग योर पार्डन अच्छा ते इस तरह करी सकने हो तुसा अपना नंबर इत्थे स्टूडियो ले को छोड़ी जाओ ते ए जेडी गल ई तफसील नाल मैं तुसा नाल करी सकना वा
ना ना बिल्कुल मैं सो के अपना नंबर चाहिए दिसा सो तफसील इस गल करी करे ते ए के असा पहले अब पहले आने असा पहले उसला आने सन के असा सिर्फ उन की कोठी ना अपना हिस्सा दिता सी हुन ओ पूरी कोठी पर कब्जा करी किंदा वरना
तुसा के इंग्लैंड निकल करने हो पाकिस्तान नहीं करने हो
ना ना हाँ इधर कालगढ़ निकल करने हो
जी कुछ है नहीं
कालगढ़ इस्लामगढ़ कालगढ़ उधर निकल करने हाँ
ओ कुछ है पाकिस्तान है
पाकिस्तान आजाद कश्मीर
अच्छा then unfortunately I can't help you unfortunately, क्योंकि that's in Pakistan और पाकिस्तान ही जाना and मैं इंग्लैंड की गल कर रहा हूँ ये पाकिस्तान ना लोड़ते नहीं
ना पर कई बारी इस राह ने ना कि इंग्लैंड ना लो था उन्हें क्या हो दबदबे विच फिर जान बुझी जाने गल्लां
जी unfortunately my practicing certificate does not allow me to practice out of England or Wales at this precise moment
उन्हें क्या सेक्शन 21 ना दे सकने
जी
उन्हें की सेक्शन 21 ना दे सकने
Sorry, I beg your pardon, I'm sneezing quite a bit today. Section 21, G. The brothers are going to take your number and I'll give you a call. मैं तुझे फोन कर सा
ना चलो ठीक है अगर तुम मदद करी छोड़ी है तो पलाज सोना बच्चे जीन तुसाने
Okay, assalamu alaikum. Sorry about the foreign language for those that don't understand Urdu. The brother, he was listening into the show and unfortunately he's got an issue in Pakistan and he wants me to serve him with the Section 21 notice. So I did say to him, I will get back to him. So Mr. Aftab, just hold fire. I will take your number off these guys and I will get into contact with you accordingly and we'll take matters from there. Again, we do practice litigation in my firm and I mean a couple of the solicitors do deal with overseas cases, so they will assist you further. And unfortunately, I'm sorry to hear about your dad as well. So again, we were talking about, before we took the call, we were talking about suspended or postponed possession orders, and we've just covered how they work. And going on, an order to adjourn the case can even be made. So it can be, an adjournment means that the case cannot be decided yet and there's a need of a delay for the hearing itself. This can be done indefinitely or for a fixed period of time. For example, this can happen if you and your landlord don't agree on the type of tenancy agreement you hold. If the judge gives you more time to sort out your housing benefit or your financial circumstances, or for example, if it's rent arrears and you're only in arrears of £100 but previously your history was pretty much clean and you were always up to date when it came to your rent arrears, or if the judge requires more evidence in order to make a decision, then again he'll adjourn the case. If the case is adjourned, you may be given a date for another court hearing, i.e. if it's adjourned for 6 weeks on the date of hearing, then you will, because obviously it's a fixed term. But if it's adjourned indefinitely, they'll wait for you to contact them and take it thereafter. And or if, as the tenant, the landlord says to the tenant, if the landlord reapplies to the court after the fixed period of time, or if the circumstances of the case change. However, in the meantime, during this period, as a tenant, the tenant has the right to remain in that house, in the home. In that particular house or premises, the tenant has the right to remain there. And again, there could also be a court order to dismiss the case when it comes to Section 8 notices. The court may decide that your case should be dismissed because there is no reason why you should be evicted. This is also known as striking out the case, or you could also phrase it as the case has been struck out. Or the case obviously can be struck out if the landlord does not have the right to apply for possession. He served a defective notice. He's got no right, has he? I mean, in order, that's why we're talking about how is the notice effective. Because if the notice is defective, then you have no right of possession as a landlord. or the landlord cannot prove any legal reasoning as to why he wants you out of the property. I mean, he can't just walk in willy-nilly and say, listen, get out of my house. Or he's not followed the correct procedure for bringing the case to the court. He's just walked in one day and said, yeah, you've got Section 8, get out. He can't just do that, or the landlord cannot just do that upon a tenant. It has to be followed by strict procedural rules and regulations. If the case has been struck out, the tenant has the right to remain in the property or the home with the same conditions as before, and there will be no change. If there's been a money judgment against the tenant in an order that says the tenant has to pay a certain amount of money, as the tenant will have to pay that amount of money regardless of whether the tenant's evicted or not. Unfortunately, I know now, talking about money judgments, a lot of people are thinking money, and what's going to happen with money judgment? Are we going to get a bad credit rating? Are we going to be able to progress in our future? Will I be able to take out a mortgage? Unfortunately, a money judgment will affect your credit history and credit rating, and it will make it hard. It could possibly make it hard for you to find a new home. And again, I did say the court may put out a court order for court costs. The court may decide you must pay all or some of your landlord's legal costs, and this will happen if there's a possession order that's made, if the case is adjourned, or you leave the property after the landlord starts the court case but before the order. So the court case has been started, but you've left the property, and now the landlord has just decided to take it to court. So upon the notice and between possession, as the tenant, you decide to get up, pack your bags and leave, then unfortunately you will have to pay your landlord's legal costs and court fees. So alhamdulillah, that's Section 8 covered as well. So I mean, we did go through Section 8 notices under the Housing Act 1988. We did talk about when it could be granted, unlike the Section 21. I mean, there are similarities, but yet there are differences as well. I'm sure the show will cover them in, well, what I tried to be in the best of details possible. And again, a Section 8 notice can be served at any time during the life of the tenancy. However, the landlord has to have a reasonable reason as to why. And these are divided into two sections: mandatory reasons / grounds, and discretionary reasons / grounds. Mandatory reasons, and upon the mandatory grounds, possession will be granted because they're mandatory. Discretionary grounds, I mean, it's just the name says it all. It's upon the discretion of the judge whether he believes it's reasonable for the possession to be granted or the eviction to be granted or not. Again, a landlord must give the tenant 2 weeks to 2 months notice upon serving the Section 8 notice, and the type of possession order can vary depending on the ground of the Section 8 that you make. That has been made. I mean, when it comes to rent arrears and the mandatory grounds, more than likely it'll be an outright possession order, meaning that you'll be given 14 days to leave the property. However, as a tenant, don't get scared, don't think you have 14 days. So upon the possession order, you have 14 days on that date. It doesn't mean after on the Section 8, upon receiving the Section 8 notice, out of the property 14 days. No, it means if it goes to court and the landlord proceeds, again, like we mentioned previously, for a claim for possession, then possession order is granted from the date of the hearing or the grant of the possession order. You as the tenant have 14 days to vacate the property. Again, as I mentioned previously before as well, in exceptional circumstances, i.e. there's somebody that's terminally ill or they're severely ill, their health conditions are severely affected, they've got mobility issues or what have you, or there's a single mother with young children, her children are very young, like one's 2 years old and the other one's 6 months old, then the judge will give will grant 6 weeks from the date of the hearing. However, it depends totally on your circumstances, and it's only in exceptional circumstances that the judges will actually be that lenient upon granting the order. We spoke about suspended and postponed possession orders, and a suspended or postponed possession order means that you can stay in your home as long as you keep to the conditions that have been set out in the postponed possession order. And I gave you an example of that. For example, you are ordered to pay off £50 weekly or £200 monthly. Just say £200 on a monthly basis on top of your rent towards your rent arrears. As long as you comply with these conditions, you'll be safe, and the order will carry on until you pay off, and then you're back to normal and you go back to your normal living conditions and circumstances. And we spoke about adjournment of case, and I did say to you that adjournment basically means, just the hearing will be prolonged or adjourned for either an indefinite period or a specified fixed date will be given. And this obviously can only happen this will happen in certain circumstances where certain things occur. Again, thank you for tuning in today and listening to the Ask Your Lawyer show. It was a pleasure hosting you and being your host, and also being the guest. Unfortunately, Mr. Amr Qazi did text me, and he does apologize. He did apologize, and he did say, look, please tell the listeners and tell the staff as well, I'm extremely sorry. And on that note, inshallah, I'll see you probably next month now. Assalamu alaikum wa rahmatullahi wa barakatuh.
Thank you for listening to our podcast. Why not tune in to our live stream at inspirefm.org and follow and subscribe to our social media platforms at Inspire FM Luton.